case briefs, and so much more. LSData's got what you're looking for.
In 1997, the Wisconsin Supreme Court heard the case of McEvoy ex rel. Finn v. Group Health Cooperative of Eau Claire, which centered on the question of whether HMOs could be held liable for bad faith when making decisions about out-of-network care, just as traditional insurance companies are. The case arose after Angela, a 13-year-old girl with anorexia nervosa, had her 6 weeks of approved inpatient treatment at a Minnesota hospital prematurely discontinued by her HMO, Group Health Cooperative of Eau Claire Inc., GHC. The decision led to Angela relapsing and being readmitted to the hospital, with GHC denying further coverage and forcing Angela to pay for her treatment out of pocket. Angela and her mother subsequently filed a complaint against GHC, alleging bad faith on the company's part. GHC argued that the bad faith tort did not apply to HMOs and that the medical malpractice statute precluded any bad faith claims. However, the court sided with the McEvoys, determining that the tort of bad faith applied to all HMOs making out-of-network benefit decisions and that the medical malpractice statute did not preclude their claims. The court ultimately ruled that HMOs making such decisions were insurers for the purposes of applying the bad faith tort. Therefore, HMOs could be held legally liable if they unreasonably denied requests for care, failed to investigate those requests, or actively worked to prevent the discovery of the truth during that process. The claims brought forth by the McEvoys were for breach of contract and bad faith tort, not medical malpractice. The circuit court had erred in granting summary judgment, and GHC was not entitled to judgment as a matter of law.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of climb.